Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of Public International Law, let us learn the new topic extradition. Extradition is the handing over of an alleged offender by one state to another. Extradition denotes the process whereby one state surrenders to another state at its request a person accused or convicted of a criminal offense committed against the law of the requesting state, such requesting state being competent to try the alleged offender. So, in simple words, we can say that extradition is delivery of a criminal or a fugitive from justice by one country to another country on sufficient grounds. Fugitive is nothing but a person who has ran away from one country to another country after committing a crime. So, some jurists have given a definition. Let us look into that. According to Oppenheim, extradition is the delivery of an accused or convicted individual to the state on whose territory he is alleged to have committed crime by the state on whose territory the alleged criminal happens to be for the time being. If an alleged offender is in a territory other than the state seeking to exercise jurisdiction, the lawful method of securing his return to stand trial is to request his extradition. Extradition, as a rule, is by bipartite treaty. There is no duty to extradite in the absence of a treaty. Requests for the extradition of fugitive criminals are made through diplomatic representatives resident in the foreign states concerned. Upon receiving such a request, the foreign government institutes a judicial investigation to determine whether there is sufficient evidence in accordance with the local law to warrant the arrest of the fugitive. So, in simple words, we can say that for example, a person has committed an offense in A country and flies away to B country to escape from the punishment. In such circumstances, A country requests B country to extradite that person. And for the extradition, two countries, A and B countries, should have a bipartite agreement regarding extradition. Then only the extradition in the state, the extradition is possible. And another condition is that they have to show, the country has to show sufficient evidence and on which ground he has to be extradited. Only after investigation they will extradite that person. If there is a prima facie case of guilt, the fugitive is to be surrendered. When the fugitive is returned, he must be tried for the offence mentioned in the request for his extradition and for no other crime. So, what are the evidence provided for the extradition? Only based on that offence only, that person has to be prosecuted. What are the conditions for extradition? So, we have certain rules and conditions for extradition. What are the rules? A fugitive criminal shall not be surrendered if the offence is a political nature. So, if there is a political offence, the fugitive criminal will not be arrested. It is a we have seen that it is worldwide accepted that extradition between countries can welcome in cases of criminals only and not for political offenders. In the international law, extradition for the political criminals is not permitted. So, in the case of Castiglione case, he is from Switzerland and he has taken part in political disturbances in Switzerland. In this course, he killed municipal commissioner. In the extradition proceedings, the British court has ordered the release of Castiglione on the ground that the offence was political, as Castiglione has fired the shot with the intention of and in furtherance of the object of getting rid of the government. So, in this case, in Castiglione's case, he is from Switzerland and Castiglione is a leader of some group and he killed a member, he killed a municipal commissioner and he fled to England. So what happened? The Swiss government requested British government to extradite Castiglione. But British government refused because this is a political offence and we cannot extradite Castiglione, they said. So if the fugitive is a political offender, we cannot extradite that fugitive. Next is military, religious and trifling offences are not general subject of extraditing proceedings. The third one is the fugitive demanded shall not be liable to tried for any offense other than that mentioned in the request for extradition. So what are the, if he is committed for a crime, then for a murder, then only he has to be extradited on the guilt of murder only and not for any other offense. So in the case of USA versus Russia, a sailor was surrendered by Great Britain to USA to stand trial for murder, but he was tried for inflicting cruel injuries. The Supreme Court of USA on appeal quashed the conviction as he was tried for an offense other than one mentioned in the request of extradition. So in this case also, what is mentioned in the extradition request, only on that grounds only the person has to be prosecuted and not on any other offense. The crime must be an offense in both requesting as well as in surrendering state. This is based on the principle of double criminality. Double criminality is nothing but we have few offenses like murder, terrorism, offenses relating to narcotic drugs. These are all the severe offenses. In almost all the countries, this is considered as an offense. So the criminal offense by the offense which is committed should be accepted as a crime in both the countries. Then it is called double criminality. We have another case in Eisler extradition case. Gerhard Eisler, an alien communist convicted to America for some criminal offences, and he fled to England. He was arrested by the British police and tried before the magistrate. The British magistrate discharged him as an offence for perjury, for which he was convicted in America and did not fall technically under the offence of perjury in England. This case emphasizes the principle of double criminality in extradition law. So here we can say that perjury is a criminal nature in any country, because giving false witness, being a false witness or telling false is a perjury, and it is considered as a criminal offence in all the countries. So this is called double criminality in the case of Eisler. So we have next thing. There must be a prima facie evidence of the guilt of the fugitive criminal before he is surrendered to the state demanding his extradition. The requested state must satisfy itself that there is a prima facie evidence of guilt of the fugitive. If there is no such evidence, the fugitive cannot be extradited. So we have Singh, where Nepal government satisfied there was a prima facie evidence of the guilt of the fugitive criminal before he was surrendered to India. So there should be some kind of evidence, prima facie evidence, and that should be satisfied with the extraditing country. Then only extradition can be possible. So law and practice of extradition in different countries. How different countries are using this extradition rules and practicing it. The universal practice of states surrender fugitive offenders only under extradition agreements. Only if there is agreement, then only extradition is possible. The law of Great Britain and USA appears to be strongly against extradition of the fugitive offenders in the absence of extradition treaty applications. So if there is no treaty between the two countries, then extradition is not possible. Some states like Italy, France and Germany have adopted the principle of never extraditing their own subjects to a foreign state, but of punishing their own subjects for committing grave crimes abroad. So some countries like Italy, France and Germany have are against these extradition processes. So we see India's position on the extradition. The Indian Extradition Act 1962 lays down the procedure for the surrendering of fugitive criminal after being satisfied that a prima facie case has been made out in support of the requisition. The Indian government can refuse to apprehend the fugitive criminal if the crime is of political character. The Indian Act substantially follows the provisions of British Extradition Act 1935. So in India also, if that is a political offence, then he cannot be extradited. He or she cannot be extradited. And another one is, in extradition cases, there must be an extraditable person and an extraditable crime. There are two practical difficulties about extradition which have prevented the growth of uniform rule on the subject. There is no agreement on the definition of certain crimes, the possibility of the process of extradition be employed to get hold of any person who is really wanted, not for an ordinary crime but for a political offence. So we have such rules and regulations on which agreements are the extradition agreements are there. Only if there is a certain kind of agreements, then only extradition can be possible. The modern states almost invariably exclude political offences from the operation of law of extradition. The Montevideo Convention on Extradition 1933 made a provision that if a state did not extradite its own citizen for a trial to another foreign state for crimes committed by him there, such state was under an obligation to prosecute him for such crime. So we have such rules and regulations where we follow the extradition processes.